Hello and welcome everyone. I hope you have a nice day today. I want to start this introduction with a very quick question for all of you. Have you ever watched a courtroom drama and wondered how did they know what to ask? Or maybe you have sat through a cross examination and thought, what's actually really happened behind the scene? How do we get the truth from the investigating officer? And well, today we are going to find out from someone who lived, master, and turn it into an art form. For over past 25 years, our distinguished Mr. Subash has not just practiced criminal law, but he has navigated it with most intense moment, stood before the judges and questioned witnesses who didn't want to be questioned, and used words not just as tools but weapons of clarity. He's here today to share with us the topic the art of cross examination. And trust me, this is more than just asking questions. This is about strategy, this is about psychology, and this is about timing and the subtle dance between control and revelation. So, why wasting time? Please join me and give a huge warm welcome to Mr. Subash. Mr. Subash, the floor is yours.
All right. Thank you very much, Dr. Chi, for that wonderful introduction. My dear friend, I've known for last few years. We always work together. Okay. Now let me start with our topic: art of cross-examination, traps to avoid in a criminal trial. Okay. My basically today I just want to give as much as information pertaining to the art of cross-examination, the mistakes that we all should avoid. We should learn to avoid all these mistakes so that we can uh, ultimately win our case. Because that is what we want, and we all understand that cross-examination is a tool to find out the truth from the witness. Okay. Now, having said that, I've prepared slides for today. Okay, my sessions is I'm thinking to do
Mr. Subash, you are muted. Wait.
okay. I'm sorry. I do
Okay.
not know why. Okay. So I will give the seminar for up to 5 o'clock, and then from 5 to 5:15, I leave everyone a chance. I give everyone a chance to ask questions. Please ask me questions. I will try my best to answer the question. Okay. Now, can we move to the first slide? Okay. Before I go to the jugular, the important one, so we all must understand the importance of cross-examination. Most cases are won or lost on cross-examination. This is exactly the sort of case where cross-examination was critical, pivotal, vital, and quite determinative as to where the truth lay. That means if your cross-examination is superb, you can just win that case. A key concern of any clients, let's say a client wants to come and see you, somebody recommended uh, you to be the lawyer, they will come, the first thing they want to know, they will type, say how many cases you have done and how good you are, how good you are in your cross-examination and whether you can break the witness. That is client's hope and what they want you to help them in demolishing the case for the prosecution. Okay, of course, proper cross-examination maximize chances of favorable result. Okay, this is basically, I just want to give you idea. But okay, now before I tell you all what are the things that we need to avoid during cross-examination, I'll give you some idea using Malaysian case law, right? How a cross-examination went wrong, which means the counsel did not ask the question or did not frame it properly until the damaging answer was given by the witness. So can we move to the next slide? This is the case, a drug case, right? In PP against Muhammad Fahmi Amza. The issue was, right, the identity of the person who threw the packet from a house. Okay, that is the question because what happened was, roughly the prosecution witness was saying that saya nampak satu orang baling paket dadah daripada tingkap dan saya terus masuk ke rumah tersebut, saya nampak seorang dalam yang pakai sarung. Okay, now that is the facts. The another facts that was also given roughly is that other than there's one man who was a clad in sarung, also there is another male who was inside the room. Okay, so far now we have one person who the police claim has thrown the packet from the window, and but when he went inside, he saw one man with sarung, another man also there. So now there's already a doubt who who actually threw the packet out of the window. If the good cross-examiner, they will just leave the situations like that. Okay, they will not ask further, right? So of course we want to ask the next question, which we shouldn't ask. Dr. Chi, can we move to the next slide? Yeah. So the question the lawyer asked was, the defense counsel, you are not sure that it was the accused who threw the packet out of the window, right? Because there are two person. So he naturally wants to ask, sebenarnya you tak pastikan, tak pasti sama ada OKT, orang kena tuduh tu yang membuang paket daripada tingkap tu kan? Betul kan? You tak pastikan. To the dismay of the lawyer, the answer was that was given by the policeman was it was the accused, right? So the problem is the moment the prosecution witness said it was the accused, now all the doubt that was there during the case where we thought where there are two person, this doubt was solved by the answer from the witness. This is a very much a bad cross-examination, right? So instead of done, you'll be wondering, so of course you wanted to know, right, that there's nothing wrong in that question, right? No, you must understand the question that should have been asked is should be framed in such a way that I put it to you, right? My contention is, or I put it to you that it was not the accused who threw the packet out of the window. So the moment if he answers yes or no, I disagree or I agree, at least he's safe, right? Or the best still, the best if I'm the counsel, I will just left it. I will never ask this question because I will just let the doubt remain if there are two person. And in this case, what happened was there's also a finding, there is a fact that of course, when that person threw the packet of drug outside, then the policeman went to the place near the bumbung. There's a roof there. They found two packets. So the judge was saying Of course, when you throw the packet, there's only one packet will be there. Now the police is saying, oh, there are two packet of drugs there. So which is which now, right? That fact saved the accused for that day. But the previous question, of course, from there is no doubt, from there is a doubt, the council's question ended up was saying that, oh, it was the accused was throwing. Okay, but of course ultimately the case was won there. So can we go to that case, Fami Amza? I think the last portion. Okay, let me tell you the which one. Okay, we can go to this paragraph where can you see the paragraph where whether the packet that was thrown out of the window of the room did in fact certain contain exhibit. Yeah, the subject matter, correct. Okay. So you all look at this. It says the subject matter of the charge against the accused is Exhibit P9 and 10. In order to hold the as a prima facie case, right? In order to, can everyone see that? Dr. Chi, can you make it big? The early one seems to be okay. Dr. Chi, can you? Okay, okay. So, what? Can you go a little bit up? Okay. So I read again. The subject matter of the charge against the accused is the exhibit. There are two exhibits. In order to hold that there is a prima facie case against the accused, there must be evidence to link this exhibit to the packet he threw. Okay. Such evidence is dependent on the testimony of PW5 and 6. PW5 saw the accused throwing out something, right? And PW6 saw a packet flying out of the window, right? So what I'm saying is that when you ask question and you wanted to show that there are doubt, make sure before you ask the next question whether that question is really necessary or not. If you think there's already a doubt based on that, please do not ask question. That is what I want to say. Okay, I will share this case in the group, so not to worry. Fami Amza. This is a very good case of of how we can avoid asking question that is will kill you during the cross examination. Okay, never ask a question unless you can control the answer. Okay, okay, Dr. Chi, can we move to the next slide? The next one. Okay, so what is cross examination? I've given two case law there. Next slide. Okay, of course, in Kamalan Sheikh Mohammed 2013 4 CLJ, it says that cross examination has been described in various ways. It is as follows, right? So these two cases will give you definition of cross examination. And according to Muhammad Irwan Bunma Abdullah, cross examination is a quiet art of advocacy, which means you can never be a good cross examiner the day you're called to the bar. You have to follow your seniors. You go to court, right? You go to court. You listen how senior lawyers cross-examine, you learn, you buy books on how to cross-examine, you study, then you put into practice, right? I took many years to realize what I did my initial year of practice was wrong, right? I'll just share. In my first year of practice, my first two trial, I really did not even put question to the pengadu. I was asking questions to IO, then other, not even pengadu. Then finally, when the judgment came out, I lost. I lost my first case in my career. Then that is when I learned where I went wrong, right? So these are the cases that give you some ideas. Okay. Shall we move to the next slide? The purpose of cross-examination to test the credibility of the witness, to challenge the fact status in EIC, to put the defense version of facts. Failure to cross-examine may amount to acceptance of evidence. This is what are the purpose of cross-examination. Okay. Now, can we move to the another slide? Power of cross-examiners. When you cross-examine, you got a power to ask leading question. You can impeach your witness, not your opponent's witness. You can test the accuracy, veracity, and credibility. Okay. Okay, the next slide. When you do cross-examination, you must put the witness on notice that testimony is disputed, right? You must tell the witness why you disagree, okay? And you must put your version also, okay? And then question must relate to the matters within the witness knowledge, which means do not put the question that the witness don't have a personal knowledge, right? If the prosecution call all the witness who doesn't have a personal knowledge on the uh, allegation that you want to challenge, you can put to the IO. You say daripada siasatan kamu, inilah yang berlaku, inilah, just put that to the IO, right? And this is very important, avoid speculative or baseless suggestion, right? The moment you say something that is baseless, yang tak masuk akal, something does not make sense, the judge will think you don't have a good defense. Okay. Okay. Now we move to the important part of the topic for today. Okay. That is things to avoid. Things to avoid during cross examination. Okay. Number one, please do not ask the same question asked by DPP during his examination is in EIC when you start cross-examining that witness. The danger is that, let's say, during EIC, you're doing this, let's say, the witness is saying that, oh, orang kena tuduh sudah pukul saya, dia pakai kayu dan berdarah and all that. Okay, they already said, okay, this is quite damaging to you in the EIC as expected. Please do not go and ask the witness, oh tadi kamu cakap OKT yang pukul kamu kan? Okay. Tadi kamu cakap kamu berdarah kan? Okay. Tadi kamu cakap kamu terlalu sakit apabila dipukul. Now, the moment you repeat what the pengadu told, the complainant told in AIC, now you are influencing the judge that that facts are the real facts. That facts are not disputed. You see, we are human beings. You go and tell the same thing that your opponent said, the DPP said, you ask same question, the judge will think that his mind will operate, oh, okay, more than the earlier damage. So now you'll be damaged for the second time. The case will be damaged second time. So please do not repeat any facts that does not favor you. My style, if I want to ask any question, whatever thing that the complainant said that was favoring me, my client, I will repeat that. That's psychology, you see. That means, example, tadi kamu kata, for other case, OKT pada masa itu, let's say there are two accused in the room, right? For the drug case. Tadi kamu kata OKT kedua, which is my client, dia berada jauh, jauh dalam bilik itu kan? Tadi itu yang apa yang kamu katakan, bukan dekat dengan dadah kan? Right. So I will only repeat the facts that is favorable and that was said by the witness. That one, that's my style. Okay, so you decide what are the facts that is favorable to you. Okay. Okay, this the another interesting point is number two, asking inconsistent or contradictory put question. Of course, put question means soalan cadangan, right? I put it to you. I put it to you. The accused did not hold the packet of drugs. I put it to you. Accused did not beat you. I put it to you. Accused did not run away. Right? But you must understand when you ask question, put questions like this, make sure your version it is not inconsistent with the earlier, right? I want to demonstrate this one using a case law. The case law, can I invite Dr. Chi to refer to the case of Stephen Kingsley?
Stephen Kingsley.
Uh, I think it's paragraph 20 and
Yeah.
21.
Paragraph
20 and 21. So you go to 21 first.
2021. Are we together? Sir, can you see the screen?
Yeah, I can. Okay. You see, I will illustrate to you. You look at the paragraph 20, right? Okay, okay. Now, in this case, is a drug case where the council wanted to say that, there is, blue carbon papers there, and then the prosecution did not explain how the brown tapes came to be wrapped around the plastic packets. And they're saying that chain of evidence, rantaian keterangan, telah putus. Chain of evidence relating to the drug exhibit remain intact. So there is no explanation. Okay. So now in this, so the judge was saying, in this respect, we note that the prosecution witness involved in the handling of exhibit were not seriously challenged on their identification. That means they are saying lawyer did not do a good job. They did not seriously challenge. Okay. Then it says the only challenge to the SP2's evidence was by way of put question, which SP2 denied. So if you look at that two question, number one, the lawyer asked, bukan semua bungkusan yang dijumpai dikemukakan di mahkamah. Okay, the prosecution witness says tak setuju. Number two, barang kes yang dirampas bukan yang dalam kes ini. You see, this lawyer was asking a question, right? First, he says, not all the thing that was found near the accused was brought to court. Not all. That okay. The second one, he is saying, oh, semua barang kes yang dirampas. That means all barang kes yang dirampas that you brought to court, right? It is not the one that was seized at the crime scene, the house, right? You are contradicting yourself, right? First, you say bukan semua, which means if you say bukan semua bungkusan, that means some bungkusan is already dikemukakan di mahkamah. Then you say, right? Semua barang kes ini bukan barang kes yang kamu rampas, right? That is a contradiction. Can you move the second one? That shows, so the judge says, paragraph 21, even the two put question were not even consistent and in fact contradictory. On one hand, it was put as to that not all the exhibit seized were produced in court, meaning to say some exhibit were produced. On the other hand, it was put to him that all the exhibit in court were not the exhibit seized. So please, the problem I think arose in this case, lawyer did not prepare his question properly. That means before you go to, for cross-examination, you must see what are the questions that you want to cross. Okay. So these are the things you should avoid. Asking a question or put question that are very much inconsistent to another. Okay. Number three, can we go back to the slide, the same slide? Things to avoid. Okay, number three, question that do not support, do not ask question that do not support the defense theory. Okay, which means if you have if you have a theory, right, you must ask question that will support your defense, not go against your defense. So, which means you must sit down before you go to court, decide what are the defense I'm going to take for this case. Let's say you have your defense in the murder case is alibi, which we are saying that your client was not around on that fated day. You ask along that line, you see. Okay, this one maybe you want to take note. It is not there. Um, the case that is normally I rely on is Muhammad Abbas Danus Bakson, I think. 2006, 3 CLJ, page 880, where Gopal Sriram said, right, all the points that was made in unsworn statement were never put to the prosecution witness, right? Which means your defense, you decide, then you put questions to the relevant witness during the prosecution case. Don't wait until defense is called. There are a lot of mistakes normally by young lawyers. They wait until defense is called. They forget to put relevant defense through the questions during the prosecution case. So most of the time, we defenses, if you don't have the relevant witness, we always put to the IO. Okay. Okay. The next things that you should avoid is introducing prejudicial evidence against your client. So I go back to that case, Fahmi Amza, right? Remember the question is, right? Uh, sebenarnya kamu tak pasti OKT yang membuang darah itu kan? Because the question was framed in such a way, right? If I'm the witness, I can say sebenarnya saya pasti, saya tak sebenarnya saya pasti. Okay. The other day, I was asking a question to a witness. First, that witness says, my client brought a luggage bag. He saw the luggage bag, supposedly that contained drugs. So I took the risk, and then he says, saya agak-agak bag ini yang OKT bawa masa dia masuk ke dalam rumah. So when I looked at the evidence, first, it was shocker to me because I didn't expect that witness to say that, going to say that, because my client was giving the instruction that no one was around at that material time. So, so I was shocked. So I was just, but I saw the client, not 100% very sure when he was to give it. So I just wanted to pound on him. So I was like waiting for my moment. So I said, lucky when the photograph was, it shows the luggage bag was black in color. In court, it was blue in color. So I told, okay, you tengok ini bag warna apa? Warna hitam. Itu bag dalam gambar warna apa? Warna biru. So you sebenarnya tak pasti kan? itulah beg yang dibawa oleh OKT. And to my surprise, and I was very fortunate, he answered, saya tak pasti. He agreed with me. So I was so happy because I managed to create a doubt there. But after reading this case law, now you understand how you frame the question. So there, I was saying, I put it to you. You are not sure. Not I. I. If you forget to put, I put it to you. Saya cadangkan. So that will bring you a prejudicial evidence against your client. I hope I made it clear how to ask questions like this. Okay. Now we move to another part. Please. Okay. There are a lot of things uh, that appears very important in criminal trial. Okay, one of it is the judges and the DPP will look at what are the questions that you didn't ask or defense counsel did not ask when the important prosecution witness gave evidence, right? So the moment they found out you did not ask question on this important thing, they will write and write and write long judgment saying counsel did not ask this question. Counsel did not ask this question. Counsel did not ask this question. So be careful when the prosecution witness is giving evidence against your client. Listen carefully, right? So, okay, how you can do? See, of course, if you are the only counsel who's taking down the notes and you are preparing to cross-examine on the same day, so I know it's very difficult for me. That is why I always invite some of the junior lawyers to sit next to me. So what they will do, they will take the notes for me. All right. If you have a chance when you're doing a criminal matter or even civil matter for that matter, okay, you have a chance. You can ask your good friend to follow you. You can ask your LA to follow you. You can ask your even chambering, if you have a chambering, to sit down and record the evidence so that you will listen when the prosecution witness give evidence. And then you see, right? These are the important thing. Just highlight, highlight, highlight. What are the important thing, right? Then you ask question, right? You know, right? Always for me, my style is all the important things I highlight. I put a comment there to cross, to cross, to cross, to cross, to cross, to deny, to deny, to deny, to deny, right? I put a one column there. So that is where you pick up the important thing, right? And just to be on the safe side, right? Normally what I will do after asking, sebenarnya keterangan kamu yang kamu mengatakan OKT telah membuang dadah selepas kamu nampak dia adalah tidak benar. So I put that, okay? Then I will ask, keterangan kamu yang mengatakan OKT melarikan diri semasa kamu sampai ke tempat kejadian adalah tidak benar. So I'll put there, tidak benar, tidak benar, tidak benar, tidak benar, tidak benar. Okay. And I will conclude my cross-examination by saying, segala keterangan kamu yang kamu berikan terhadap anak guam saya adalah untuk kuatkan kes polis dan langsung tidak benar. So actually, I'm trying to cover the whole thing, and so even of course there might be some evidence to say, but I just take the safe zone. I said all the evidence you that one damaging against my client all not true. Okay, so that is very important. So never forget to ask question, and all this failure normally occurs when you don't prepare, you don't write down questions before you cross-examine. Another thing that I will always do is that if I feel I they say read the room, all right? If let's say the cross examination going to take some time, okay, okay, and then maybe you feel you're not ready to ask question on that day, right? If possible, right? look at the mood of the judge, look at the mood of the DPP. If you can postpone to another day on the important witness, you apply to reserve cross on that day. Because nobody can force, nobody is actually forcing you, you must do it, unless, of course, it is an old case. The witness is very difficult to come, witness is from Sabah, Sarawak, they come out. Okay, maybe that kind of witness, okay, you cannot postpone, ask for reserve cross. But if you think that are not the situation, you can always ask for reserve cross. So the advantage will be you ask for next day to cross-examine. I'm just talking about the important witness. So that when you go back, you just prepare the note, look at the notes, your idea will come, right? You prepare and and then the idea will come to ask questions and all. You can even, bring the notes to see a senior lawyer. Bos, ini itu hari saya ada buat ini, you boleh bagi idea tak macam mana saya nak cross this witness. Sometimes he will give you some extra points. So okay. So that is failure to cross-examine on material witness. Okay. Number two, what you should avoid is arguing with the witness. This one, I was doing one case in Malacca. This old lady was arguing with me. Then I was saying, I put it to you that it was you who actually push my client. Then she said, "Oh, how you know? I know she is my daughter. She is telling lies. You are paid to tell. Ask questions like this. Such a silly questions." She was arguing with me. I was like, "Oh my God, that's already a 70 years old lady." The moment if I start arguing with that lady, my heart will sympathize with that person. So I will lose the battle using psychology. So what I did was I just kept quiet. I said, "Madam, I'm here. I'm doing my job. I understand. You must understand. I have a job to do. Please do not argue with me. You just answer my question." So the moment the DPP look at you, the judge looked at you and said, "Ini lawyer bagus lah dia, baik na lawyer." So that might even help you to win your case. Because please remember, shouting in court, raising a voice in court does not mean that you can have an upper hand on the witness. Because you must understand the judge is looking at you. You go to court based on your reputation. Okay. If you be nice to the witness, right? Most of the time they will be nice to you. So try avoid being someone who look very harsh, someone who shout, badger at the witness, right? Be courteous. So I have won a lot of case by being courteous, and the witness answer my question without realizing that are dangerous to the prosecution case. Some example, I have asked in the rape case, after asking few question, I asked, "Adik setuju dengan saya, semua keterangan adik yang berikan hari ini menunjukkan bahawa adik tidak pernah dirogol oleh anak buah saya." And she said, "Yes, setuju." I was like, okay. So everybody looked at me and said I didn't show any demeanor. Then they postponed to another day, again asked the same question. "Setuju dengan saya kamu tidak pernah dirogol oleh anak buah saya?" Setuju. Right? And she was like, and they were so surprised that question she can even answer yes. So be nice to people. They do not know what they're answering. So sometimes because they are tensed up. And when you are nice, they be thinking, "Ni lawyer banyak bagus." So they were thinking they are not your enemy. So they will probably, feel, "Oh, baik." So they will probably agree with you. And the other day when I was asking question, I was asking, this dedication was my client was involved in a robbery. He took the phone of that his friend. Well, of course, his friend. The friend, and they just took it and exchanged the phone and all that. And but to then that client actually lodged a report. He said my client took his phone and it's robbery. I was thinking, after all the evidence in court, I looked at the witness. I said, berdasarkan kepada semua keterangan yang kamu berikan, anak buah saya tidak pernah menyamun kamu. Oh. And he said yes. So be calm, ask question politely, right? Frame the question. They might fall into your trap, right? They will never know when they are going to fall in the trap. Being courteous, that's the advantage. Okay, now I think number four is what I've said earlier. Do not repeat EIC. Okay, so we moved on to another aspect of cross-examination, which you should avoid asking why question. Okay, do not ask why question. Why you have like you're asking the complainant why you ask my client to come to your place, why my client has to pay certain amount of money to your account, why this, why that. uh, the moment you ask why, you are not controlling the witness, right? I said, okay, you're not controlling the witness because you're letting the witness answer a question very wide, right? He can say whatever he wants. So always control the witness, never ask why. Okay. Because I know there's some lawyers, you ask a question, said sebenarnya pada masa itu anak buah saya tidak melarikan diri. So the question, let's say, then the witness will say, saya tak setuju. Then the lawyer will ask, kenapa tak setuju? Then if you ask question like that, then the policeman will say, sebenarnya saya nampak dia larikan tu dan saya pada masa itu juga saya ingat anggota saya ada ambil video yang pada masa itu dia tengah melarikan diri selepas kami sampai ke tempat serbuan dan tempat itu pada masa itu kami telah membawa media bersama kami. Why you ask all these questions? They have got all the explanation. Now from there is a doubt, there is from doubt, there's already evidence to say that your client in fact was running. See, because the law says that when you try to run from the scene, probably you have a guilty knowledge, right? So that is one aspect of it. So never ask why question, right? So you cannot control the witness. See, another thing that you should avoid is misstating the evidence. Okay, why? What will happen is, let's say during the EIC, let's say the police was saying, saya nampak dua orang sedang berlari bersama dengan OKT, right? You already, but there is already evidence like that. But when you are taking down notes and all that, and then you heard it like you're not sure, but you said tadi kamu katakan dalam keterangan, but you're not writing down, you see, you're not writing down, you just listen and all that. So you heard, but you're not. Then you ask question. Tadi kamu masa EIC examination in chief, kamu tadi katakan ada 4 orang yang berlari dengan UKT. So you are misstating the evidence. Why? You are not concentrating. So you must be alert all time. Okay. So in order to avoid misstating the evidence when you're not sure, if you have someone who's taking down notes, ask it. Can I? Or you can even ask, stand down 5 minutes or 10 minutes before you cross. Like, don't worry about, asking time 5 minutes or 10 minutes before you start your cross examination. Okay. Most judges, they are very pleasant. They will give you a chance, right? Sometimes, I feel I just want to tie up some in my prepared list of cross examination question. If I sense that there are, you see, the court wants to continue uh, with our turn. There are no other case. Court want to listen to your case. EIC already finished at 1 o'clock, right? There's no chance to postpone the matter. or no chance to ask for another day, right? Or so you can ask stand down. Let's say you finish around 12, right? So you stand down 5 minutes, 10 minutes, you can ask. So don't worry about. Never mind if they ask you. If you say kenapa perlu stand down? Oh, so the standard answer will be ada dua tiga fakta yang saya perlu dapat arahan daripada anak buah. Of course, they cannot say no. That can say no. Okay. So the next thing you should avoid is being baited by opposing counsel. You see, sometimes your opposing counsel will use psychology. Okay. So he will sometimes, try to, object here and there for simple things and try to provoke you and all that. Right? Don't play to his game. Okay. Just be professional. Right? Don't engage shouting at him or raising voice and all. Because you must understand the judge is looking at you. If you behave very well, okay, and your opponent is not behaving, the judge most likely will give you chance more, right? And also, okay, another habit that I see among lawyers, they want to object simply for the sake of object, okay? So that is very, do not simply object for gain. You see, if you are kind of lawyer, you always object whenever DPP asks questions, right? I know, it's a hearsay evidence, but just choose your very strong objection because if keep on, objecting, even it's a simple, right? If doesn't damage your case, of course, even if it's a for me, my style is if I see that is something that is ought to be objected, but it does not affect my case, I will not object. Right? They're asking leading question, right? But they're not going to damage my case. I'll just don't object, right? Because I will only stand up after few after few questions and all that. I will stand up. The moment I stand up, judge know that this lawyer really have a valid point in objecting, and most likely my objection will be allowed. Okay, because judge no, I will not simply object. So avoid that habit of simply, objecting for nothing. Just give me 1 minute. Okay. Okay, this one we move to the next habit. Cross-examining when the witness caused no harm. Okay. Let's say the prosecution witness gave all the evidence. He did not implicate your client. All right. There are two clients, two OKT, right? Two accused. All the evidence was against the OKT one. Okay. And okay, so now the turn is the OKT one's lawyer already finished cross-examine and all that. Nothing implicating your client. You just stand up, look at the judge, right? Say, Young Arif, saya tiada apa-apa soalan, right? Judge who looked at you will be very happy when the moment you say, judge will love you the moment you say, I have no cross, right? Because when there is no harm caused, why you want to ask question? Huh? Why you want to ask question for what? And then, right? Uh, from there is no evidence, suddenly there will be evidence against your client. And also I realize, the question is like you're asking something that you do not know the answer, right? Because you don't control the answer. So I think before we conclude, I want to share there are two more case law that I want to show, right? Stephen. Okay. Dr. Chi, can you share Hari Singh? You go to Hari Singh is yeah, paragraph 33. Go to paragraph 33.
Is this shown on the screen? Paragraph 3.
No, 33.
33.
Uh, So I want to give a chance to all of you to look at the how the questions were asked, right? And you got all the yes answer. Okay, I just go. Um, this is the accept from the judgment. So as I repeat, walau bagaimanapun saksi SP10 bersetuju dengan cadangan peguam bahawa jika CCTV di restoran dan CCTV di IPK disiasat dan diperolehi, ia mungkin akan dapat membantu mahkamah sekiranya untuk mencapai satu keputusan yang adil. Alright? So look at how the lawyer framed the question to get yes answer. Okay, soalan pertama. Puan Zu, malangnya atas sebab-sebab yang tidak dapat dianggap Puan Zu tidak memperolehi rakaman. Okay, betul? Ya, betul. So, number two. Puan Zu, maklumat adalah kononnya bahawa ada satu penama Yap telah dibebaskan di kawasan ini, tetapi Puan setuju dengan saya bila tidak ada CCTV, saya tak dapat compare betul ke perkara ini terjadi. Betul tak Puan? Betul. Satu saja, saya nak cadangkan Puan Zu, nak kata tak tahu, tak boleh cakaplah pasal perkara ini, Puan Zu arahkan gambar diambil. Betul? Betul. Okey. Cuma Puan Zu tak buat dapatkan CCTV. So, Puan tak dapatkan CCTV untuk tentukan versi, betul tak? Betul. Puan Zu, saya cadangkan mungkin kalau mahkamah saya cadangkan Puan Zu, perkara tersebut mungkin membantu mahkamah yang boleh ini untuk mencapai satu keputusan yang adil di dalam menentukan adakah perkara tersebut atau benar atau tidak. That means if you got the CCTV, you can assist the court to arrive at the fair decision. Yes or no? Yes. So look at how this question were framed to get yes, yes, yes answer. So you all look at the Hari Singh, how this question were asked and when you the DPP when your case hinges on a CCTV and they did not make any attempt to verify and to get the CCTV. This is the question how you frame it to the example to ask question to get yes answer. Okay. So we go to the last slide. So cross-examination is about control, right? You control the witness, not witness control you, okay? And one thing I always say is that if the witness is saying something, let's say in your cross-examination, they always say, when you ask question, all right, the witness will say, boleh tak saya jelaskan? Boleh sir. So if you're a nice lawyer, you say silakan apa you nak jelaskan. That is something that you should avoid. The moment that the witness say, boleh tak saya jelaskan? Saya kata, Puan, boleh jelaskan tapi bukan dengan saya. Boleh jelaskan dengan DPP. Okay? You just control. Or the best way, normally what I will do is that the moment before I start cross-examining the witness, I will say, okay, Puan, hari ini bila saya soal balas, okay, apa-apa soalan yang saya tanya, kalau tak faham, minta saya jelaskan. Dan lagi satu, kebiasaannya soalan yang saya tanya adalah soalan berbentuk cadangan. Saya akan tanya setuju atau tidak setuju, Puan, just bagi tahu setuju atau tidak setuju. Saya tidak perlukan sebarang penjelasan. Okay. So, nak penjelasan nanti DPP boleh turn DPP. Tu. So the moment you actually when you start your cross examination, you inform the witness. They know this witness is the lawyer is only asking setuju atau tidak setuju. So they will not make any attempt to explain. Because if you don't tell them the beginning, okay, then they will say, oh, saya nak jelaskan. Then you will say, Hakim, macam mana ni? Saya nak jelaskan, dia tak bagi saya peluang, macam mana all that. So better you start explaining and telling, you control the witness from the very beginning, okay? And There's another way normally I do. You see, you must understand. Let's say tomorrow is your cross examination. You're going to cross examine the victim tomorrow. Okay. From today, the complainant would be thinking that lawyer is your enemy. Okay, that means that lawyer is my enemy. So I'm the victim. Thinking, that lawyer is not. So I'm not going to agree to whatever he says and all that. So the prejudice is always there. So what do you do? The first three or four question, you ask question that is neutral. Uh, then you just mellow down. So the witness will say, lawyer ni baik sangat. Okay, lawyer ni. So the moment she thinks like that, chances are when you ask important question, she might agree with you. But of course, this is all strategy. So there's another thing that you should understand. Just because you are paid, with paid, you don't have to ask so many questions, right? Just ask what is necessary, right? It doesn't mean that you have to ask so many questions to win a case, right? So less is often more. Okay. So, and of course, if you develop a habit asking question, even the non-photographer also you want to ask question, Guru store also you want to ask 10, 15 question. Every time you go to court, the judge look at you, ada berapa soalan ni? Mesti panjang ni lawyer. So they don't like that. So always remember, right? Your reputation precedes you next time. So not important witness, no need to cross, or one or two questions will do. Okay. And finally, professionalism and fairness will impress the court, right? Not being harsh. You don't bully the witness. Don't be rude in court, right? A lot of cross examinations, they are done by gentlemen lawyers. They win cases, right? You always remember, even if you ask the witness, setuju, right, sebenarnya kamu bercakap bohong. There is one way of asking. There's another way of asking. Of course, we know they are telling lies, right? Of course, you cannot tell. You say, don't say, sebenarnya kamu bercakap bohong di mahkamah. You just say, sebenarnya kamu tidak bercakap benar di mahkamah. Okay? The second one sounds very soft, but you bring home the point that he's not telling the truth. Okay. So that will bring an end to this seminar. So I hope everyone understand better with my explanation today. So I leave to Dr. Chi to conduct this session.
Yeah, thank you, Mr. Subash, for such a wonderful talk. We now invite the audience for Q&A session. Should you have any question, you can turn on the mic and feel free to ask anything regards to this topic. And I'm sure Mr. Subash will not be mindful if you want to ask something that is out of scope also.
Yeah, please, please. No, no issues. Anything also you can ask. I will try to answer.
Yes, please.
Hello, hi, Mr. Subash.
Hi.
Thank you so much for your insight. I have one question. Basically, if our own witness is the one who's actually being a hostile witness, how
Mhm.
to go about it? Yep. How to go about it? Basically, can we
Oh,
actually impeach him or something?
that is not part of today's topic, right?
Yep, yep. Sorry.
Okay. Okay. No issues. Uh, you see, that is very important. You know why all this happened, is uh, some lawyers, they do not interview the witness, interview the witness before they question him in court. Okay. So, you see, to coach a witness is wrong, but to interview the witness, lead him to evidence, the documents, you talk to him and all that, that will prevent, the witness turning hostile in court.
I see.
But of course, if he turn hostile in court, what choice you have? You have to impeach him. But it look bad on you,
Yep,
because
yep.
you don't prepare the witness very well in court. Because if he's saying something, for the first time in court and you do not know about it, right? That's some that that shows the lack of preparations and how long you have interviewed the witness before. So always interview.
Mhm.
I will tell you. So always interview the witness many times. Important with your own witness. Bring him to the documents, uh,
Mhm.
and he will probably able to perform well in court.
I see. Okay, okay. Thank you so much, Mrs. Bash.
No, no problem. My pleasure.
Mr. Subash, if you notice the screen, there's one question posted by our friend Rajan.
Mm.
And it sounds like this. In a case with multiple prosecution witnesses, there are situations where a particular fact has already been admitted or clearly answered by one witness, for example, a juru gamba or another supporting witness. However, if the same question is repeated to the IO, it may open the door for further explanation during re-examination, which could potentially harm the defense. So his question is this. From the strategic point of view, is it sufficient for the defense to secure the admission from just one witness? Maybe we can just take a one question first, Mr. Subash.
Okay, I do understand. Okay, let's say whatever you want, you already got from your Juru Gamba. There's no need to ask the IO. And because Juru Gamba is only tendering a photograph, and they say uh, picture tells thousand words, right? So if the Juru Gamba, you can only confirm what is there in the Gamba, right? You know. So if you already got that, why you want to ask IO for to ask that question? Because you must understand the moment that prosecution witness, whether it's Juru Gamba or Juru Store, anybody, I just already gave you that one particular point that you're looking for, right? And that that came out in during the cross examination. Okay, so enough. Just be happy, thank God, and then just keep quiet. No need to ask another witness. Okay, number
Okay.
two.
Number two, I think it is quite overlapping. If the point has already been established, would it be safer not to repeat the same question to the IO, even though the IO is the main witness?
No, you must understand. If you ask pose to the question to the relevant witness, and that relevant witness got the personal knowledge, has already agreed with that, right? There is no need to ask a question to IO. I don't understand what you mean by main witness. The prosecution witness who have a knowledge of the incident who should be the star witness, the main witness, not the IO. So if you already got from the relevant witness, let's say there is already a witness who said OKT was not at the scene of the crime, right? And then he was the one who was inside the shop when the robbery occurred. And there are five, let's say, four people entered the shop to steal, and the OKT is not one of them. They already said that the cashier already said OKT is not one of them. He never jumped. Just keep quiet. After you got the answer, no need to ask anyone. So no need. It is be safer not to repeat. If that earlier person who already got a personal knowledge. And third one, in such circumstances, does choosing not to ask place the defense in safer position. It cannot be used against you because one prosecution witness already said something in favor of you.
Okay. Is there any other question?
I welcome questions because this is where we get to share our knowledge and all that. Sometimes there are a lot of things that we cannot ask uh, when uh, when we are busy, but when there's opportunity, please use that opportunity.
I may have one question coming from my personal experience, sir.
Oh,
What is your strategy to tackle those uncooperative witness? For example, They don't want to say they is yes or no, but they say they have forgotten. Sudah
For,
lupa.
no, there's nothing much you can do lah. Kalau lupa means lupa lah. So
Lupa,
how can you
lupa.
force a witness? How can you force a witness to say ingat benda yang sudah lupa? So of course you can do it in your submissions. This witness uh, does not inspire confidence. He have forgotten a lot of things. You see, some pattern I've noticed during the EIC they remember everything,
Hmm.
but when you start cross-examine, they said saya lupa, saya lupa, saya lupa. So
Ah,
you can see how this wonderful witness can remember everything in the EIC, but
hmm.
when but that's of course he's displaying biasness. That point is against that particular witness. That you cannot see the witness is credible. I've seen
Hmm.
so many witnesses. Suddenly EIC semua pun boleh ingat.
Okay, understood. So
Yeah.
there is another question coming from Ranjan. If
Mm.
another defense lawyer question, for example, OKT1, harm my client being OKT2, how do I safely fix it through my own cross-examination?
That okay, that one I must say that is a very difficult situation. That is why when you choose a case, you find out who is the OKT one's lawyer is before you pick up the case. If
Okay.
the OKT one's lawyer is someone you cannot work together, you have to reconsider your position. Because normally we all, if you do a case, in a particular state and all that, only the same lawyers, we all very close and all that. We will not harm any our friends, client and all that. But of course, it's sometimes that lawyer is from the another state. That client is someone. That lawyer is someone who have to have a reputation like that. Well, if we ask question, right? You can just straight away. That's why you make sure that lawyer asks, apakah, let's say you are the from second OKT, and that lawyer asks, apakah OKT 1 dan OKT 2 sedang buat masa serbuan itu dilakukan. OKT 1's lawyer has no basis to ask what OKT 2 was doing at that material time. You get up and he said, court, Yang Arif, I hope my learned friend only limit the question to his own client.
Hmm.
Okay. So you can then straight away object like that. But of course, you want to, let's say, there are some, but of course, there are situations where when OKT1 has asked, a lawyer of the OKT1 asks question, the answer given by the witness, sometimes they are too excited. They say, pada saya nampak OKT 1 bersama dengan OKT kedua juga sedang memimpin bank and all that. So you just put it to that witness, keterangan kamu yang OKT 2 sedang pegang bank itu tidak benar. You just challenge.
Hmm.
Always challenge the witness by putting his evidence is not true. So any question, any last question? If
Subash?
not,
Subash?
yeah. Yeah.
Okay. Sorry. Just now you mentioned that if the question raised doubt, if your question has already raised the doubt, then no need to ask further. Kan? Does it? I don't think it works for civil matters.
I see.
Maybe because criminal matters is beyond reasonable doubt kan. Kita ialah on balance of probability. So one witness may say something to the effect that can cause will be to our benefit. Tapi another witness will say something yang will damage our defense kan. So can you say something about this from your experience? How the difference when you conduct a civil case? In short, ringkas pun tak apa. I know this is on cross-examination in criminal litigation. Ringkas pun tak apa.
Mr. Subash, if I can shed more light on this, probably I'll give you a scenario which we usually face, especially in accident matters, whereby the sergeant who comes, when we ask him pertinent questions, he would stress that is either dalam siasatan, or he would stress that that was not taken down, or probably the important damage aspects of photographs is not taken, right? This is to find support for the defendant's version. More often than not, the IO would say that whichever that is not favoring the defendant, the photographs are not finished, statement from the witness has not taken, or even there was a passenger in the motor car of the defendant, the passenger's witness statement is not taken. That's one example. And sometimes when the employers testify in court, what they would do is that they would testify that, oh, the plaintiff is unable to return to work, even though the medical report from defendant's report suggests is able to work, the fractures united. They'll magnify the testimony in order to find support for the plaintiff. Of course, we're going to challenge, but the thing is, when the witness is not truthful and it supports the plaintiff's evidence, in this scenario, how do we have the evidence in documentary proof? We don't have, but how are you going to further strengthen to challenge this evidence in court? Maybe you could shed light on this.
Okay. Now, before that, Kaisha was asking question. I don't know whether that two questions. Okay, I'll answer. Can I answer Kaisha first?
Sure, go ahead.
Okay. Okay, for Aisha's question, okay, okay, I appreciate Aisha's question. The thing is that, what I'm saying is that, okay, not all cases are like, okay, so you decide based on your experience. Okay, if there is, okay, if, let's say, even in a civil matter, whether the doubt that was already created goes to the root of the matter, and whether there is a need for you to even to ask question. But if the doubt is not so much, that means doubt is not something you still need some other statements to to help you. You may ask questions to supplement that doubt. So I think it is will take judgment from us. That means it's your call whether to ask question, or there is a need to ask question, and of course, like I said, the safe zone will be, if you think you still have to want to cover yourself, use frame questions in such a way that if they will just setuju or tak setuju. Saya katakan kepada kamu, sebenarnya sorry, saya setuju tak jika saya katakan A, B, C, D. Setuju tak jika saya katakan? Because even if there is whatever answer that earlier given, right? You just put there. Sebenarnya, there's one more extra question. Setuju tak saya katakan, or something like that. So when you frame, you can always say saya setuju or tak setuju. So you be on a safe zone. So you ask question, still you challenge that version and say sebenarnya saya setuju jika saya katakan macam ni, macam ni. So that is be a safe zone. So always the way you frame your question is very important. For me, it is always important to frame it setuju atau tidak jika saya katakan, compared to to get the answer ya atau tidak. So because the moment you said setuju, sebenarnya kamu ada makan nasi pada hari itu, you can always say saya setuju atau saya tak setuju, rather than kamu tak makan nasi kan hari itu, he will say tak. So sometimes it open to doubt. Tak makan maknanya whether he tak makan or he disagree with the question, or saya tak makan nasi means. But of course, when you say you tak makan nasi hari itu, if he say yes, you can always say yes, saya tak makan nasi. Kamu tak makan nasi, when he say tak makan. So they always remember all this can open to doubt. Even one of the High Court judge last time, S. Nandabalan, he says he prefers the question framed setuju atau tidak setuju. That means you agree or disagree rather than yes to get yes or no questions. Okay, I hope I answered Aisha's question.
Thanks, Subash.
Okay, welcome. Okay, my brother, Mr. Mutu, has asked a question. You see, of course, if the witness are not helping us in such a way, sometimes what we will do is that we ask the particular police and all that. If you have taken photograph, okay, this is your investigation. You did not take from this angle. You did not if you it is sebenarnya kamu boleh ambil dari angle ini kan, tak ada yang menghalang kamu boleh ambil kan, tapi kalau kamu ambil, kamu boleh bantu mendapat keadilan untuk kes ni kan. Setuju? All this you put whatever investigation he didn't do or choose not to. So actually you can do it this way, right? You didn't do, right? You had the opportunity, right? You failed to do, right? It is an omission on your part, right? So you list down all the questions, just show that it is a sloppy investigation. Then you said, and also you say this witness is biased. This witness is biased. It's not fair. Investigating officer, it is not to come to court and help plaintiff or defendant. Investigation officer means they have to be fair in the investigation, right? So if they are showing bias and all that, just say he's biased. Okay, brother, did I answer your question? I hope I answered the question.
Yes, you've answered the question. Thank you.
Thank you.
Thank you.
Okay. Okay, can Dr. Chi,
Okay.
I think if there's no more question, can I ask just invite one or two people to just give a review? Of this class, because I want to see what are the things that you all enjoyed or didn't enjoy, and what are the things that you look forward next time and on the presentations. Can I invite anyone?
Can I give a review? Okay.
Yeah, please.
I think being in practice in years is not enough. You know what? With Mr. Subash presentation today, I have recollected some of the cardinal and important principles in cross-examination. So because I have a trial in next 2-3 days, now I'm thinking what I prepared for. I should actually avoid this, avoid that. And being courteous and being soft to the witness is one way to win. And I think I personally have encountered that many times during trial. And with you sharing the criminal elements of it, I think it's very insightful, because you know what, it also is applicable to civil matters, and I'm very grateful, and I really thank you for all this knowledge which you have shared with us. Thank you so much. Really
Okay, thank you.
appreciate it.
Thank you, my brother.
Thank you.
Two more, because I'm quite excited. So, because are you all looking forward for many seminars like this? Anyone? So can I have last two person review, please?
We are looking for more. I'll be a participant as well.
Okay, thank you. You're my great supporter. Okay, any last two? How many participants you have for now? 16. I think I'm particularly very interested to hear Puan Murni's view for today's class. Puan Murni, can you give your view?
Okay, sorry, I tak boleh nak buka video. Okay,
Tak apa.
okay, thank you. This is my first time join any of the session. Okay, and then as for me, walaupun I dah 5 in practice, tapi I masih lagi saya masih lagi takut lah macam nak buat kita nak buat I tak tahu macam mana nak mulakan. So I ada case next month, so that's why I tengok benda ni kata very very useful lah for me. And then baru I tahu macam mana nak guna sikit-sikit, and then the benda yang you dah bagi tu dekat I tu I akan cuba gunakan lah. And then hopefully nanti kita, kalau I nak tanya apa-apa ke, I can ask you.
Yeah, boleh, sure. Hope. So, did you find it beneficial today? Anything you?
Of course. That's why daripada situ kita tahu macam apa kita nak tanya, and then skill nak mendengar tu I tak berapa pandai. Macam mana time tu kita nak buat soalan kan?
Yes. All this will take years. That's why it's all experience, and I encourage you to read more. To read more and you understand more. Okay. Thank you, Mr.
Okay, thank you all.
Okay. Can we have last person to review?
Subash, can I say something?
Yes.
Okay. It's a bit of my bad habit lah. Sebab I banyak bila buat cross examination. I love doing cross examination because I can ask any question I like, you know. But I tend to be too long-winded. and I tend to
Oh.
ask too many questions. But I think I want my thoughts is that I want to cover all grounds, you know, so that I can apa ni, especially when you talk about negligence, there are ingredients kan, nuisance ada ingredients, so each and every ingredient kita nak cover all grounds. But I think after listening to you, there are things that I can things yang useful for me to like go back and look at my questions and try to cut down the questions, so that I can, you know, go straight to the issues, issues to be tried. Don't have to go too far off, because like Puan Lalawati and siapa judge mana, dia kata Puan Aisyah, kalau Puan Aisyah so panjang ni, you know. So I think that is that is quite negative, negative comment from the judge. So maybe I can use your tips today, you know, and try and cut short my cross examination. I like cross examination. It is something fun, you know.
Yeah, of course, of course.
Yes.
Okay.
And then
Thank you.
yeah, thank you. And if I can suggest, kalau buat jangan Sabtu tengah hari, boleh tak kita buat malam ke, you know, because like today clash dengan ada conveyancing punya seminar tau.
Aduh. So kita bukan Kak, sebenarnya masalah ni semua orang nak weekend, Sabtu dan Ahad.
Okay.
Sabtu dan Ahad, diorang tak nak weekdays. Lepas tu pagi kalau kita buat, dia kata pagi bangun lambat sebab Saturday you know, ada banyak benda family day. Lepas tu Sabtu, Ahad normally, you know lah, I'm from KL to JB, JB to KL. So normally I go back to JB from KL on Sunday. So I tak boleh buat on Sunday. So it leaves me with only Saturday. So I ada kekangan masa. And then malam my wife always minta I bawa anak-anak pergi makan dengan family day. So itu masalah saya Kak. Tapi in future we can plan.
Faham. Thank you. It's just a thought.
Yeah, thanks.
Last thing, will we be getting the notes?
Oh, you mean the slides?
The slides, yeah.
Boleh. I PM you personally.
Boleh. Thank you.
Okay. Another thing, I just forgot to psychologically forgot to inform you earlier, is that let's say you have 10 questions and all that, right? And then the judge asks you, Dr. Chi, ini hari macam mana you punya, berapa lama you ambil untuk cross examine? Then you say mungkin 1 jam. The moment you say 1 jam, 2 jam, judge is like, okay, bila lah ini lawyer mau habis ni and all that lah, you know, thinking all that. So just to give a clue to the judge, let's say lah, you know, you have covered almost 1 hour, you have already covered almost your all that, and then you have only few more questions to go, right? Always inform the judge, Yang Arif, Tuan Hakim, saya ada lagi 2 soalan lagi dan saya boleh wrap cross. So I can just saya boleh conclude this session cross. So bila Hakim, sebab mula-mula Hakim tak tahu bila you nak habis cross. Lepas tu tiba-tiba you cakap, Yang Arif, saya ada 2 soalan je. Hakim be very happy. Oh, okay, at least we are going to end this cross. So normally that is what I will tell Yarif, and also never tell the judge, Yarif, 1 soalan je lagi saya nak habiskan, because when you say 1 soalan lagi, suddenly the witness tell an answer, then you say, Yarif, lagi 1 boleh tak? Then tadi kan you dah cakap lagi 1 soalan je, right? So let's say you have 3 more questions, right? Always say, Yarif, saya lagi 4 soalan saja, and you think after 2 or 3 questions you can finish, then you'll be happy. Otherwise, judge, tadi you cakap 3 soalan je, tadi you cakap 2 je. Always play like that. Okay, thank you for all the participants. I'm so happy that I shared a little bit of what I know. Okay, and then whoever didn't give review just now, please give review in our group, not the main group. So in the main group, the seminar group, the main group, so then other people who wants to participate in the future can see how this class is taken place. And please, all of you, please give review in the group, the main group seminar. I look forward to that. And you have any suggestion as to the topics, you can always put that in the group. Thank you, everyone, and thank you, Dr. Chi, my very
Thank
good
you
friend.
very much. With that, we end our session. Thank you so much for your attendance. Have a great weekend ahead. Thank you so much.
Thank you.
Bye
Bye-bye.
bye, all.
Bye.
Thank you, Subash. Thank you, Dr. Chi.
Bye
Thank
bye.
you, Kak.
Have a
Thank
good
you.
Sunday.
You all.
Bye.
Okay.